All right, welcome to the deep dive. Today we're going to be taking a deep dive into transitional justice. So this is that kind of intersection of philosophy and law and politics, and how societies try to move forward after war.
Yeah, I mean it's a very sort of multidisciplinary subject.
Yeah, absolutely. And as somebody who you know appreciates getting to the meat of the issue, the core of a complicated issue without a lot of extra fat, I think this is a great episode for you. This is a think of this as your direct route to understanding how societies attempt to create order out of the chaos of violent conflict.
Yeah, and today we're looking at an entry from the Stanford Encyclopedia of Philosophy. It's a very long article, very thorough, and it really sort of gives us an idea of both the challenges of transitional justice, but also a lot of different sort of approaches and different ways of thinking about these dilemmas that we're going to talk about today. So it's very good in that regard. There's a lot of different perspectives that the article takes on how societies actually grapple with these past wrongs and violence.
Okay, so the source material focuses on three main types of transitional policies. And so that's really going to be the framework for our discussion today.
Yeah.
Those are war crime tribunals, truth commissions, and lustration policies.
Yeah.
So let's start with war crime tribunals, maybe since that's first.
Yeah, sounds good. And I think what's interesting is that right away we see the central tension, and I think this is sort of the key tension. The key sort of almost contradiction at the heart of transitional justice. This idea that we want peace, we want stability, especially after a violent conflict, but we also want justice and we want accountability for the human rights abuses that have occurred.
Yeah.
So it's sort of like, how do we, it's this balancing act, between these two things that are often, pulling in different directions.
Right, like trying to heal but still needing to address the wounds.
Right.
And the article actually gives some really concrete examples of like how pursuing these seemingly compatible goals, peace and justice, can actually lead to significant clashes.
Yeah, exactly. And I think, one of the things that is sort of the clearest examples of this are prosecutions. So, we often think, that prosecutions are essential to, achieving justice. But the article brings up the good point that, sometimes prosecutions can lead to instability.
Yeah.
They can destabilize, a fragile political situation. The people who are being prosecuted, maybe their followers or people who supported them or their cause might see these prosecutions as, being politically motivated.
Yeah.
as retribution. And so, that can kind of reignite the conflicts that the society is trying to overcome. So, that's the dilemma, right? Is prosecuting, these people who committed these horrible acts, is that worth, risking, the peace that's trying to be, established?
Yeah, and there's legal complexities too. Like the article talks about how, post-war prosecutions sometimes involve departures from the established legal norms.
Right.
And they give examples like Nuremberg, where there was the application of retroactive criminalization.
Mm-hmm.
And, they talk about this doctrine of command responsibility, which, holds superiors accountable. But that's not always a perfect fit with traditional legal principles.
Yeah, that's right. And I think, what's interesting is that, in a lot of ways, these tribunals or courts that are formed during, periods of transitional justice, they're trying to build a new legal architecture.
Mm-hmm.
So, they're taking these principles, these legal principles, but they're also sort of having to reinterpret them or come up with new sort of frameworks to fit the crimes that have happened.
Right.
And so, it's really interesting to see how these how flexible is the law? How much can we actually kind of, change these principles to fit, these unique circumstances?
I recall that they talk about, these legal innovations at Nuremberg and things like that.
Mm-hmm.
And they also point out that, like, the nature of trials, with their rules of evidence and focus on specific charges, that can actually limit the scope of the historical record.
Right.
Because, like if you compare that to a truth commission, for instance,
Yeah.
that gathers a much wider range of narratives and information.
Right.
So there's an epistemic difference there.
Yeah, that's a really good point. And I think, the article does a good job of pointing out that there's this difference between sort of, legal truth, which, is what you're trying to get at in a trial,
Mhm.
where you have to follow these very specific rules of procedure and evidence. But then there's also this broader kind of truth, this broader kind of societal need to understand, what happened.
Right.
And so, these two things might not always align.
Yeah, and then you have, like victims, for instance,
Right.
giving testimonies in trials. It can be adversarial,
Hmm.
subject to cross-examination.
Right.
And that, can be really difficult for victims. That can be re-traumatizing in a
Yeah.
sense. And it may not encourage that kind of full and open sharing of experiences that you get, say with the Truth Commission.
Right. Yeah. No, that's a good point.
So that brings us to illustration, which is this idea of removing, individuals associated with the former, oppressive regime from positions of power,
Right.
in the new government. And that seems logical, right? Like that seems like a step that would be taken to build trust. But the article cautions, that if it's implemented too broadly, it can actually severely impair the functionality of government.
Yeah, that's right. Because you might be removing people who actually, have a lot of, experience and know-how,
Yeah.
and you need those people to actually kind of, run the government and make sure that it's functioning. And so yeah, you can end up in a situation where, the government is just sort of kind of paralyzed and people don't trust it because it's not actually able to provide any kind of, services or run effectively.
And it seems like this idea of lustration brings up this whole philosophical concept of dirty hands, right? Which they mention,
Yeah.
like with Machiavelli and Sartre and Walser.
Yeah, exactly.
Yeah.
This idea that sometimes, you have to do things that might seem wrong on a small scale, to achieve a greater good.
Right.
And that's a really sort of kind of a difficult dilemma, I think, for a lot of people to think about.
Right. It's not a simple, binary, good action, bad action. It's choosing between like two kind of undesirable options.
Right. Yeah.
And each one has its own kind of ethical implications.
Exactly. And I think that's why, the article talks about, moral luck, this idea from Nagel and Williams that, sometimes, it's not about one side being right and one side being wrong. It's just about, the circumstances that you're in and the difficult choices that you have to make. And the idea that, we have these sort of deeply held moral intuitions, as people, but sometimes those intuitions kind of they pull us in different direction.
Right.
They clash with each other.
And it seems like this whole idea of balancing peace and justice, it's not a static thing. It's like it's an ongoing, negotiation. It's a back and forth.
Yeah.
It's a dynamic interplay of these values.
Exactly. And we see that, throughout history. Like the article gives the example of Spain, where they initially had this what they called Pact of Forgetting,
Yeah.
where, they just decided not to really address the crimes of the Franco regime.
Right.
But then later on they passed this law of historical memory, where they revisited those crimes.
Yeah.
And so, it's not like it's a one-time decision. It's something that societies kind of keep coming back to and revisiting and trying to, find that balance.
Right. Right. And they also bring up like the Truth and Reconciliation Commission in South Africa.
Yeah.
As a kind of an attempt at a compromise
Yeah.
between those two things.
Yeah.
And the Gacaca courts in Rwanda.
Yeah.
Which prioritized, restoring a functional judicial system, even if it meant, sort of kind of sacrificing, some aspects of justice.
Yeah. And I think, what's interesting too is that this tension between, peace and justice, it's really kind of heightened in transitional settings, because the institutions are so fragile.
Right.
And the norms are not yet really sort of deeply embedded in the society.
Right. It's like a new house that hasn't settled yet.
Yeah, exactly.
And it can be really easy to kind of to mess things up if you're not careful. So with that understanding of this central tension, between peace and justice. Let's move on to talking about war crime tribunals, which the article gives a really nice kind of historical overview of starting with, the Nuremberg trials.
Right. Yeah.
Things are World War II.
Yeah.
And it's interesting, to learn that there was a huge debate among the Allied powers, even before the trials began, about how to deal with the defeated Nazis.
Yeah.
And you had the hardliners like Morgenthau, who were advocating for these more punitive measures.
Yeah.
Like outside the legal framework. And then you had the legalists like Stimson, who were really arguing for adherence to the the rule of law and having fair trials.
Right. And I think, what's interesting about Stimson's argument is that he basically said, that the Allies had fought this war, for these principles, for this commitment to law and to justice. Yeah.
And so to then kind of turn around and just kind of abandon those principles in the face of, these horrible crimes would be hypocritical, I think, in his view.
Yeah. And then you have like Robert Jackson's opening statement at Nuremberg, where he articulates the profound significance of choosing, the rule of law over the impulse for vengeance.
Right.
And that was a really powerful statement, I think. One that set a real precedent.
Yeah, and really sort of, set the tone for the trials.
Right.
And for the way that we think about, international justice. Right. And it's also, it's striking how the initial focus of the potential charges against the Nazis, broadened. So at first it was really about aggressive war. That was kind of the main concern. But then when they started uncovering these atrocities, in the concentration camps, it became clear that they had to include crimes against humanity as a core part of the prosecution.
Yeah, and that's a really important point, because it really kind of expanded the scope of international criminal law. It kind of showed that there were these crimes that were so horrible, that they couldn't just be ignored.
Right.
And that even though they might not have been specifically prohibited by treaties or laws at the time, that they were still fundamentally wrong.
Right.
And that the people who committed them could be held accountable.
Right. And so despite the defense arguments, about Victor's justice and the retroactivity of the charges, which we can get into in a minute, the Nuremberg trials are really widely seen as a landmark achievement, in the history of international law.
Yeah, absolutely. I mean, they really established, these key principles, like the accountability of heads of state, for their actions. And the idea that you can't just say, I was following orders.
Right.
As a defense. And I think, the other thing that's important about Nuremberg is that it created this historical record.
Yeah.
It documented these crimes in a way that had never been done before.
Right. And they mentioned briefly the Tokyo Tribunal, which followed Nuremberg, but it didn't quite, achieve that same level of historical prominence. And I think part of that was due to, challenges with, accessing records and things like that.
Yeah, there were definitely some practical challenges there.
Yeah.
And I think also there were some disagreements, among the judges involved.
Yeah.
About how to proceed. So, it's not as clear-cut a case as Nuremberg.
Yeah. Okay, so moving on, the article talks about how the development of international criminal justice didn't stop after those initial tribunals. There was this kind of lull during the Cold War, where obviously the geopolitical divisions made it really hard to achieve any kind of universal legal norms or anything like that.
Right.
But then in the 90s, after the Cold War ended, there was this kind of resurgence of international criminal justice. And so we see the establishment of the ad hoc International Criminal Tribunal for the former Yugoslavia, or ICTY, and the International Criminal Tribunal for Rwanda, or ICCR. And the article notes that the ICTY, it faced some early hurdles, particularly in terms of resources and things like that.
Yeah, that's right.
But it eventually kind of, gained some traction, and they talk about how it led to, indictments of some key figures like Karadzic and Mladic and the conviction of Plazic. And then, the ICPR also had some big, achievements,
Yeah.
the first genocide conviction by an international tribunal, and also the really important recognition of rape as a war crime.
Right. So, these tribunals were really important, in kind of further developing and solidifying, the principles of international criminal law. But one of the criticisms that they faced, and I think it's a valid criticism, is that they were operating far from the territories where these atrocities had actually occurred.
Right.
And so there was a sense that they were kind of detached,
Yeah.
from the populations that had been affected by these crimes, and so this led to this kind of new development, which is the emergence of what are called internationalized or hybrid courts.
Mm-hmm.
So these are courts that kind of blend international and domestic legal personnel and laws,
Yeah.
and they operate within the countries where the atrocities have occurred. So the article gives examples like Bosnia and Herzegovina and Kosovo and Cambodia and Sierra Leone and East Timor and
Yeah.
Lebanon, and so this was seen as a way to kind of make the justice process more local
Yeah.
and more legitimate, in the eyes of the people.
Yeah, absolutely. So then we have, this kind of, culmination of these efforts to establish a permanent framework for international criminal justice, which was the establishment of the International Criminal Court, or ICC,
Mm-hmm.
in 1998.
Right.
And the article outlines, its jurisdiction over these really grave crimes,
Yeah.
like genocide and crimes against humanity and aggression.
Yeah.
But importantly, only when they're, committed after its statute came into effect.
Right.
And they point out, of course, that the U.S. didn't ratify it.
Mm-hmm.
And there's been these ongoing debates, about its role and
Yeah.
its effectiveness. But importantly, one of the key things about the ICC is that it operates on this principle of complementarity, which means that it only intervenes when national courts are unwilling or unable to genuinely prosecute, these crimes themselves.
Yeah, and I think, that's an important point, because it really shows that the ICC is not trying to kind of replace, national courts.
Right.
It's trying to kind of supplement them,
Yeah.
and to act as a kind of, backstop, when national courts are not able to do their job.
Right. Okay, so despite all these advancements in international criminal justice,
Yeah.
through these tribunals and the ICC, there's still been some significant criticisms
Yeah.
that have been raised, and the first one, which is kind of a fundamental challenge to the legitimacy of these tribunals, is this idea of victor's justice.
Right.
Right, this argument that these legal processes are merely a tool for the victors to punish the vanquished.
Yeah, and it's a really, potent critique, and it goes back, a long way. The article quotes Thucydides, the ancient Greek historian,
Yeah.
and even, Goering, at Nuremberg.
Right.
They both kind of, articulated this skepticism about whether, justice can really be, impartial in the aftermath of conflict.
Right.
And I think, it is kind of a difficult argument to dismiss, right? I mean, it's certainly true that, if the Axis powers had won World War II, it's very likely that they would have put, Allied leaders on trial.
Right.
And then they would have, accused them of war crimes. But the article kind of, it pushes back against this critique a little bit, and it quotes this scholar, Gary Bass, who makes this distinction between the circumstances surrounding a tribunal's establishment and the fairness of its actual operation.
Right.
So his point is that, just because a victor might initiate a tribunal, that doesn't automatically mean that the tribunal is going to be unfair.
Right.
Yeah.
That
There can still be, due process, and there can still be, a fair trial. And I think, the other point that the article makes is that the kind of justice that a democratic victor pursues is going to be very different from the kind of justice that a totalitarian regime would pursue.
Yeah, that's a really, really important distinction.
Yeah.
I mean, just imagine, a hypothetical Nazi tribunal.
Right.
It would have been operating on such a different set of, legal and moral premises
Exactly.
that it's almost hard to even compare it to something like Nuremberg.
Right.
Okay, the next criticism is that of retroactivity,
Mm-hmm.
right?
Yeah.
So this idea of holding individuals accountable for actions that weren't, explicitly defined as crimes under the law at the time they were committed.
Right.
And this gets at this core legal principle, right?
Yeah.
That the Nazis used as their defense, which is, nullum crimen nulla puna sine lege, which is, no crime without law, no punishment without law.
Right.
And they talk about, the prosecution's primary strategy at Nuremberg was this positivistic strategy,
Right.
which was trying to demonstrate that existing international laws, particularly those relating to, the waging of aggressive war, did in fact, prohibit the conduct of the Nazis. And then, of course, they developed this concept of criminal conspiracy,
Right.
which was, pretty innovative at the time
Yeah.
to establish this kind of collective responsibility of entire organizations.
Right.
So they're kind of like, okay, so the laws maybe weren't perfectly clear at the time, but we can find existing laws that fit the crimes.
Right.
And so that's kind of their approach.
Yeah, exactly. And then of course there's the natural law perspective, which is more kind of a philosophical argument,
Right.
which is this idea that there are certain actions that are just inherently wrong.
Yeah.
Regardless of whether they're, specifically codified in law or not. And the article quotes, Shawcross, who was one of the British prosecutors at Nuremberg, and he makes this point, that murder was wrong, even before there were laws against it.
Oh.
I mean, it's just kind of a fundamental moral principle.
Right. It's like the quote unquote, laws of nature. It's just it's wrong.
Right.
Okay, so the next criticism then is that of selectivity.
Mm-hmm.
Right? This argument that international tribunals often focus on prosecuting, lower level perpetrators while failing to indict the senior political and military leaders who are really the ones who are responsible for orchestrating these atrocities.
Right.
And this is a pretty damaging criticism because it undermines, that notion of comprehensive, retributive justice.
Right.
And it can also, create this perception of bias.
Right.
Like they're going after the little guys, but they're letting the big guys off the hook.
Yeah. And to counter this, the article talks about this principle of command responsibility,
Yeah.
which is basically this idea that you can hold, superior officers accountable, for the crimes of their subordinates,
Right.
even if they didn't, directly order those crimes. And the idea is that, if you're in a position of command, you have a duty to prevent your subordinates from committing crimes.
Right.
And if you don't do that, then you can be held responsible.
Yeah, and so this gets applied, in the ICTY,
Right.
and it's complex. You talk about, how it was applied in the Blasky case, for instance,
Mm-hmm.
which was partially overturned. So it's not always a clear cut, kind of thing.
Right.
But it highlights this tension, between this idea of individual responsibility, which is based on direct evidence, and this idea of command responsibility, which is kind of a more kind of a broader way of thinking about responsibility.
Right. And I think, it raises this really interesting philosophical question, which is, in the context of mass atrocities, where you have these crimes that are so widespread and so systematic, do we need to rethink the way that we think about individual culpability?
Yeah.
Do we need to expand it to include people who might not have, directly committed the crimes, but who are in positions of authority and who fail to prevent them?
Right. So it's like, it's almost like a utilitarian calculus, right?
Mm-hmm.
Like the scale of the crime is so vast
Right.
that it almost necessitates a different way of thinking about individual guilt.
Right. Right. Yeah. And then of course the article also mentioned some other criticisms, like that these tribunals don't focus enough on the victims.
Yeah.
And